didn't have an attorney.
We didn't have an attorney. The only attorney there was my son.
Folks, listen. The moment you tell another attorney on the other side that either you're trying to get an attorney,
the courtroom opens with River Ridge taking on Craig and Sandra Lambert over serious lease violations and criminal activity. Tensions skyrocket as a registered sex offender is still in the home. Who will stay? Who will go? Buckle up. This is going to get intense. Subscribe for more dramatic breakdowns.
Costs are $216 for a total due of $3,617.85. And we'd ask for a default possession only judgment with writ to issue after 2 days.
Can you give me that total again? I'm sorry.
Yes, $3,617.85.
Okay, that's what I thought. All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. River Ridge versus Craig Lambert. And also Sandra Lambert.
I can't get it there. Yes, sir.
Oh,
we're here.
There they are. Hello.
Hello.
And this is a termination.
It is, Your Honor, this is an action for just cause termination of tenancy. Your Honor, an individual in the household by the name of Sean Lambert was charged with and actually pled no contest to felony children accosting for immoral purposes. I believe his sentencing was just earlier this week, Your Honor, and this is a violation of the lease agreement. And in that, the lease prohibits engaging in criminal activity in the community. And so a termination of tenancy notice was issued. And to my knowledge, the defendant's son is still residing in the home. His sentencing looks like, Your Honor, involves 3 days in jail, and he got credit for time served in the amount of 3 days. And he's now on a 5-year probation period that began on March 2nd. So he is now a registered sex offender living in the community, which my client will not allow. Your Honor, Mr. and Ms. Lambert.
I just want to be clear. The basis for the termination, is it because of his status that the lease prohibits that?
The lease
because of the activities?
It's the criminal activity specifically, Your Honor. This lease that the Lamberts are on was from prior ownership. That does not include the provision against sex offenders. It prohibits criminal activity in the community. However, the community is under new ownership and leases signed by Mr. and Ms. Lambert for the home that they live at. They own 2 homes in the community, Your Honor. One at the mailing address that's listed on the pleadings, and one at this address. And they live in the one, and their son and his wife live at the other. The lease that the Lamberts signed for the home that they live in is a lease agreement that prohibits sex offenders in the community, because this landlord prohibits sex offenders in the community. But the lease that applies to 105 is prior ownerships, and that lease specifically just prohibits criminal activity. And said criminal activity did occur in the community, and so it is grounds for termination of tenancy.
So, I think I'm understanding. So the activities that led to the no contest plea are alleged to have occurred in the community.
Yes.
I got it. Okay. That's what I want to know. All right, folks, what's your position on this?
First off, Your Honor, nothing happened in the community. We lived there. We lived for 16 years. Our sons lived with his wife for a year. And this supposedly is for immoral purposes with the children. It never happened. The police conduct, they did all this stuff, the legal stuff on it, reports and stuff. There's nothing in their reports for child molesting or anything. He just was on the phone with somebody and she coerced him into getting involved.
Hold on a second, sir. I don't know that I want to get into the details. This is going to sound a little bit weird, but I don't know that I want to get into the details of what happened. The question would be, whatever happened, did it happen on the community? Any part of it happened in the community?
No,
No,
but
All right. Are you guys gonna, was that conviction in Washington County?
It
Yes.
was, Your Honor. The case number is,
It's gonna be a circuit.
it is, Your Honor. It is 25F 41540.
11540. All right. Okay, so we'll get on Odyssey and do that. Are you folks gonna be wish to be represented by a counsel on this case?
we saw an attorney. We had a hard time finding an attorney. We saw an attorney
Okay.
yesterday. He said, number one, there is no lease, but they do have the right to have him leave. And when he leaves out of the house at 105, then we're going to have to sell it because we cannot afford to have two houses.
but there's nothing in the community.
Okay, just never mind. We have no, but what we wanted to talk about is if we could get an extension to give him time to be able to find a place to live and them time to move out.
All right, so here's what I'm gonna do, folks. I'm going to adjourn this out to the 13th next week. March 13th, 2026 at 12 noon. That's an in-person hearing down at the courthouse. That'll give you some additional time to seek an attorney. All right. And you can also feel free to contact the plaintiff's attorney's office to see what you can, if anything, work out.
And Your Honor,
Okay.
just
You did not want to
to
talk-
clarify, Your Honor, I did receive correspondence from my client on or around February 25th, indicating that the Lamberts had complained to her that they had called my office several times and that I wouldn't speak with them, but I had no record of that. And in that conversation, they had told my client that they had an attorney, and so I did not make attempts to contact them because I did not want to
You can't
speak
do
with
that.
them.
Right.
Correct. My understanding is that they were told that if they have an attorney, to have their attorney call me. If they do not currently have an attorney represent them, I'm happy to speak with them. If they intend to retain an attorney or still try to retain an attorney, then I will wait to see what the outcome is of that attempt before communicating with them. But whatever it is, they can call the office, and I'm happy to have a conversation with them to see if we can reach a resolution.
Okay.
Okay. Do you folks understand that? So
Yes.
if you're going to be, so that we're clear, if you're going to be represented by an attorney, or if you have an attorney, it's not that Ms. Dornbush doesn't want to speak with you. She is actually prohibited from having a conversation with.
Why is
have
that?
it.
We didn't have an attorney. The only attorney there was my son's.
Folks, listen. The moment you tell another attorney on the other side that either you're trying to get an attorney or that you've consulted with an attorney, they're not going to talk to you.
Oh,
They're prohibited from doing so ethically.
okay.
Okay.
The moment you say, I don't have an attorney, I'm going to represent myself, then she would be clear to talk to you.
Okay, we don't have an attorney.
At this time.
Okay, then what I'm going to suggest you do is you call her office,
Okay,
speak to her, and see
Okay.
whether or not you can work something out. Otherwise, what we will do is we'll see you on the 13th at noon. That's an in-person hearing, so you'll have to come down to the courthouse.
And
Okay?
Your Honor, I have a phone number ending 3823. Is that a good phone number for either one of you? If so, I can give
Yes.
you a call today.
yes, I would really appreciate it, honey. Thank you.
Okay,
Talk
very
to-
good. Thank you, folks.
Thank
Yep.
you. Have a good day.
Yeah.
You do the same.
All right.
Scio Farms versus Camellia Landry.
Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Here's where it gets legally tense. The judge grants an adjournment, giving the Lamberts time to find counsel and communicate with the plaintiff. Representation, ethical boundaries, and procedural rights collide. Would you handle this stress? The stakes are immense when communication gaps could sway a verdict or delay justice.
Good morning, Your Honor. My name is Catherine Perez on behalf of the defendant, and I am requesting permission to represent under the supervision of David Santa Croce pursuant to 8.120, MCL 8.120.
Whoa, stop. Is that how Santa Croce told you to say that?
Yes,
He did?
kind of,
Dude, I don't
maybe.
think he told you that way. Didn't he tell you to say like Michigan Court Rule 8.120?
Yes, he did. I
Yeah,
meant
he
Michigan
did.
Court
All
Rule
right.
8.120. I'm so sorry.
All right. And you've not been before me before, I don't think.
I have not. This is my first time here.
Is it? You nervous?
I'm feeling okay.
Okay. All right. Where are you from originally?
Cincinnati,
Okay. So
Ohio.
you're Midwestern, albeit Ohio. And where'd you go to undergrad?
Ohio State.
Oh, I'm done.
I know.
I am so done. This is really over.
I had to be honest. Candor to the tribunal.
What'd you say?
I said I had to be honest. Candor to the tribunal.
Yeah. Oh, now she wants to throw out those rules. All right. That's fine. All right, counsel, welcome aboard.
Thank
All
you.
right. What is plaintiff's claim in this case? Permission to practice is granted. Go ahead.
Thank you, Your Honor. With cost, Your Honor, $1,742.42.
All right. And counsel, what's your client's position on this?
We would like our client, the defendant, Mrs. Landry. She has been unwell health-wise. Just within the last week, she was declared incompetent, and then that pronouncement was rescinded by her psychiatrist and physician. She is not doing well, but she was still able to pay through February's rent. And it's our understanding that this case has all been about the client portal, of which she's not been able to essentially figure out because due to her health condition and age. And we have not even been able to speak to our client directly because of her health. We've been speaking through a proxy, one of her close friends. And so it is likely that we would need either a power of attorney or a guardian in this case. And just because of all these circumstances, we would like to request an adjournment for 2 weeks.
All
A
right.
2-week adjournment.
But what I'm hearing is if you can get through some of those things, it's likely that at least through February, there's going to be payment, right?
Well, there's already been February payment, but yes, likely that we'll get, like, this would not be an issue in further in preceding months or subsequent
How
months.
much is their monthly rent?
So,
Sorry.
and Your Honor, if I may, the
Yeah.
monthly rent is currently $915. There was an increase as of December 1st. The issue here, Your Honor, is that yes, Miss Landry has been making payments through February. They are generally speaking paid late, but the issue is also that they're not the full amount. Ms. Landry was sent a lease renewal offer last September. She was reminded of it several times via phone, and including in October, there was email correspondence reminding her that the lease renewal needed to be signed. The lease renewal was hand delivered to her. This was in January, Your Honor, but my client still would have honored the lease renewal had she signed it and returned it. At that time, she told the community employee that she wanted to review it and then sign it and presumably have it returned. But at this point, it had been in her possession for 4 months. It had been previously sent over for her review and approval through DocuSign. But the renewal offer letter setting forth the rent increase, which she's paying, and the month-to-month fee was sent to her in September. As far as the portal situation goes, Your Honor, this came up in the last court case that we had. And my client has really bent over backwards to try to accommodate Miss Landry and trying to get her set up in the portal so she can then do automatic payments and not have to have a physical payment dropped off at the office. My client has gone to Miss Landry's home and attempted to sit with her after she enters her credentials into the system to access her account on the portal to get that going. And they can't do it because she doesn't have a good internet signal. And she won't come up to the management office where the signal is good. And my client can't take her login and password and do it for her. They can't do that. These are her credentials. She has to be present to do it. My understanding from the last court case was that
Now the drama explodes. Ms. Landry can't access the portal. Lease renewals remain unsigned, and management struggles with health and ADA issues. Month-to-month fees pile up. Frustration, illness, and technical barriers create a perfect storm. Who's at fault? The courtroom tension skyrockets. Resolution seems almost impossible under these conditions.
Mr. Stano Croce's office was going to be trying to help her with that if it couldn't take place through management, if they couldn't come up with a plan. The plan ended up being that Miss Landry needed to come up to the management office. She hasn't done so. And unfortunately, the interactions that my client has had with Miss Landry is that when they do try to help her in person or over the phone, she ends up becoming not so friendly to deal with and threatening to call her attorneys, et cetera, at which point my client will then say, then we're going to step away because this is just irritating the situation. And so my client is stuck between a rock and a hard place of trying to get her to a point where she can get her lease signed. She can do the automatic payments through the portal, but Miss Landry has not been particularly cooperative in doing that. My client had made some, adjustments and accommodations to Miss Landry in the last court case with the expectation that the lease renewal was going to be signed for the next term beginning in January, and that this signing up registration through the portal for the automatic payments was going to take care of that because this has been a continuing issue for Miss Landry, unfortunately, for some time. And so right now we are dealing with obviously month-to-month fees that aren't being paid. And Miss Landry left a voicemail for my client on January 22nd, I believe was the date, indicating that she was aware that she had the lease agreement, that it needed to be signed and submitted. That didn't happen. So she knows what the rent increase is because she's been paying that, but she's not covering the month-to-month fee, which she had notice of. And payments are coming in late.
I think I get it. And in particular, if at some point she was declared incompetent and then that rescinded, some of these conversations probably are taking place during that period in time. And so,
yes. And Your Honor, I was speaking with Patty this morning and saying, if she's having some difficulties making these decisions and maybe there's somebody that needs to step in that can assist her. If it's been rescinded, then it also draws into question whether or not there was the requisite level of, whatever it was that drove that initial diagnosis. It's been rescinded. Obviously, I don't know, and I don't have access to her medical records to know what the driving factors are on that. Nonetheless, Your Honor, it does seem like she needs some assistance.
Well, but sometimes that can happen. Sometimes, obviously she's of a certain age, but also some of that can happen just by medication and the medication kicking in, that all of a sudden
Yeah.
now they're in a different spot.
Yeah,
So
and I
I-
totally get that, Judge. So
You're-
I would agree. I think that hopefully there's somebody that can step in and assist her, because it's putting my client, unfortunately, in an awkward situation where, they can only do so much.
Your Honor,
Are they, yes, go ahead, Mr. Tenant.
if I may, just without, I don't want to argue with Ms. Dornbush. We categorically disagree with her framing of it all. My client has end stage kidney disease, so that it's the dialysis issues that are causing the mental health issues. She can't use a portal, so the idea that she could DocuSign a new lease, the management's well aware. There's going to be an ADA and maybe a fair housing defense here. We hope to work it out. We have a friend that dropped off a check, but I just want to put on the record that we fundamentally disagree with the plaintiff's characterization. Now's not the time for trial. We need some time either to get a guardian ad litem in place, or for her to give a power of attorney to her friend who brought the check in the other day. And we hope to work this out. She's got nowhere to go. And also, to be clear about the medical, she has been in the hospital for like 2 weeks, and they're now supposedly supposed to discharge her to a long-term care facility. And she came back down with a systematic blood infection, which is super, it's not,
Okay.
she's not in a good place. Let's put it that way.
And Your
All
Honor,
right.
if I may just respond very briefly, the lease renewal goes to her email, not to the
Right.
portal, to be
Right.
very clear, number one. And number two, it was hand delivered to her by my client, which they did as a courtesy. And so,
I get all that, folks. Folks, I get all that. I've got somebody that's trying to operate, their business needs the rent paid. I've got somebody that fundamentally may not be able to do it. I think between all of these fine people here, we can find a way to work that through. And it may end up in a situation, if she has to go to a long-term care facility, that much of this might end up being moot in certain respects anyway. But here's what I'm going to do. You guys want 1 or 2 weeks to try to sort through this, because you've got to try to figure out either a GAL or at least a payee or something along those lines.
I don't
We would
object
like-
to 2 weeks, Your Honor.
All right. I'll adjourn this to March 20th, 2026 at 1 p.m. And that's an in-person proceeding, but you guys can work it out somehow, figure out how to do that. All right?
Alrighty,
Thank
thank
you.
you. Thank you, Your Honor.
All right. And thank you, Buckeye. You're all right.
Thank you. We'll see you again soon. Bye-bye.
Yes, ma'am. Scio Farms versus Julie Sharp.
The judge sets a final in-person hearing, balancing landlord rights, tenant obligations, and medical or guardianship considerations. The clock is ticking. Payments, leases, and assistance must align. This ruling could decide eviction or compliance. Like, comment, and subscribe for more shocking courtroom stories and expert breakdowns of complex cases.